MRL3701 Hockly's Insolvency Law, Chapter 3 Compulsory Sequestration. 3.1 Requirements. A court may grant an application for the sequestration of a debtor's estate if it is satisfied that, first, the applicant has established a claim which entitles him, in terms of Section 9, subsection 1, to apply for sequestration of the debtor's estate. Secondly, the debtor has committed an act of insolvency or is insolvent. And lastly, there is reason to believe that it will be to the advantage of creditors of the debtor if his estate is sequestrated, as per Section 12, subsection 1. The onus of satisfying the court on these three matters rests throughout on the sequestrating creditor. There is no onus on the debtor to disprove any element. 3.1.1 Applicant entitled to apply in terms of Section 9, subsection 1. Section 9, subsection 1 allows proceedings for the compulsory sequestration of a debtor's estate to be instituted by, first, a creditor or his agent who has a liquidated claim against the debtor for not less than R100, or secondly, two or more creditors or their agents who have liquidated claims against the debtor amounting in aggregate to not less than R200. The fact that a creditor holds security for his claim does not debar him from applying, even if the value of the security exceeds the amount of the claim. If an agent applies on behalf of the creditor, he must be authorized to do so prior to bringing the application. An applicant's lack of authority cannot be cured by ratification once the application has been launched. A liquidated claim is a monetary claim. A claim for transfer of property, for instance, does not give locus standi to apply, the amount of which is fixed by agreement, judgment, or otherwise. Examples of liquidated claims are a claim for the price of goods sold and delivered, a claim based on a provisional sentence judgment, a claim for return of the price paid under a sale which has been cancelled due to the seller's repudiation, and a delictual claim for the theft of a fixed and determinable sum of money. Examples of claims that are unliquidated are a claim for damages for failure to carry out obligations in terms of a consent paper, and a claim for payment of an untaxed attorney and a client bill of costs. If a debt is disputed, it cannot be regarded as liquidated unless it is capable of speedy and easy proof. Section 9, subsection 2 provides that a liquidated claim which has accrued but which is not yet due by the time the application is heard must be regarded as liquidated for these purposes. It follows that an agreement to give credit or allow time in which to pay is not a bar to sequestration proceedings. But if the creditor has agreed that he will not institute proceedings for recovery of the claim, or that he will refrain from suing for a definite period, or until the occurrence of a specified event, then he is precluded from applying for sequestration while the agreement is still applicable. A contractual claim cannot be considered to have accrued for purposes of Section 9, subsection 2, until the creditor has performed any reciprocal duty resting on him. This, in Sand Dune CC versus Cat 1998, it was held that a claim for rent cannot be relied upon until the lessor has made the leased premises available to the lessee for the relevant period. Neptune observed, "The position is quite different from that which exists in respect of a sale for credit or a loan of money, which is only repayable at some future date. For in both those instances, the seller and the money lender will have performed their obligations in terms of the respective agreements, and the liability to pay the purchaser and the borrower would be certain. In the case of a lease agreement, both the lessor and the lessee have future obligations, and the lessee's obligation to pay future rentals is dependent upon the lessor making the leased premises available to him. For these reasons, the applicant does not have a claim which has accrued, in the sense of which the phrase is used in Section 9, subsection 2 of the Act. The applicant must have a liquidated claim of not less than R100, both when he applies for a provisional order of sequestration and when he asks for the order to be made final. After the debtor's estate has been provisionally sequestrated, the debtor himself cannot make a payment to the sequestrating creditor so as to extinguish the latter's claim or reduce it below R100. But a third person, such as a surety, may make a payment on the debtor's behalf, and if the payment extinguishes the claim or reduces it to less than R100, the provisional order must be discharged. A creditor is not entitled to refuse payment in full, but may reject part payment by a third person. Where the sequestrating creditor's locus standi is eliminated by a payment, another creditor may intervene and apply for further provisional order of sequestration to be granted on discharge of the first order. 3.1.2 Debtor committed act of insolvency or is insolvent. Number 1. Acts of insolvency. Although a creditor may have good reason for believing that the debtor is insolvent, he will usually not be in a position to prove that the debtor's liabilities exceed his assets. Consequently, the legislature has designated certain acts or omissions by a debtor as acts of insolvency, and if the creditor can establish that the debtor has committed one or more of these acts, he may seek an order sequestrating the debtor's estate without having to prove the debtor is actually insolvent. It follows that a debtor's estate may be sequestrated even though he is technically solvent. The creditor may rely on an act of insolvency committed after commencement of sequestration proceedings, provided the necessary allegations are properly before the court. An act of insolvency need not be committed vis-a-vis the sequestrating creditor. Section 9, subsection 1 gives any creditor or the debtor the right to apply for sequestration once the debtor commits an act of insolvency, whether or not the debtor directed the act at the creditor concerned or intended it to have any bearing on that creditor's affairs. An act of insolvency committed by a spouse to a marriage in community of property operates as an act of insolvency by both spouses and accordingly is a good ground for sequestration of the joint estate and for sequestration of the separate estates of the other spouse after dissolution of the marriage by divorce. An act of insolvency may be proved and relied upon even though it is contained in a communication that would ordinarily be privileged from disclosure, such as an offer marked without prejudice sent in a genuine attempt to reach a compromise in relation to a disputed debt. In Absa Bank Limited versus Chopdad 2000, Van Schalkwyk explained the policy of the law in this regard. A creditor who undertakes the sequestration of a debtor's estate is not merely engaging in private litigation. He initiates a juridical process which can have extensive and indeed profound consequences for many other creditors, some of whom may be gravely prejudiced if the debtor is permitted to continue to trade whilst insolvent. I would therefore be inclined to draw an analogy between the individual who seeks to protect from disclosure a criminal threat upon the basis of privilege and the debtor who objects to the disclosure of an act of insolvency on the same basis. The conduct designated as acts of insolvency will now be considered. A. Absence from republic or dwelling. If he leaves the republic or being out of the republic remains absent from it or departs from his dwelling or otherwise absents himself with intent by doing so to evade or delay payment of his debts, as in Section 8, subsection A. The creditor must establish the debtor's intention to evade or delay payment of his debts. In particular, that the only probable inference to be drawn is that the debtor had this intention. Proof of departure of absence by itself is not sufficient, because a person may leave or absent himself for reasons completely unconnected with the payment or non-payment of debts. For example, to avoid a deterioration in his health or to join a close relative, or simply on account of his occupation. A factor from which the intention to evade or delay payment may be inferred is that the debtor made an appointment to make a payment and then departed without keeping it. In Estate Salzman versus Van Rooyen above, the debtor, a company director, left for another town, Cape Town, ostensibly for the purpose of visiting his wife who had fallen ill there. However, prior to his departure, he appointed another person as co-director to run the company business, disposed of his office equipment, and terminated the lease of the premises where he had been residing. He gave no address at which he could be contacted in Cape Town, and immediately on arriving there, resigned from his position as director. Thereafter, he ignored letters relating to business matters addressed to him. The court held that the inference was irresistible the debtor intended to evade payment. B. Failure to satisfy judgment. Section 8, subsection B reads, if a court has given judgment against him and he fails upon the demand of the officer whose duty it is to execute the judgment, to satisfy it, or to indicate to the officer disposable property sufficient to satisfy it, or if it appears from the return made by the officer that he has not found sufficient disposable property to satisfy the judgment. This subsection creates two separate acts of insolvency. One where the debtor, upon demand by the sheriff, fails to satisfy the judgment or to indicate disposable property sufficient to satisfy it, and the other where the sheriff, without presenting the writ to the debtor, fails to find sufficient disposable property to satisfy the judgment and states this fact on his return. The two acts, although separate, are not independent of each other. The second act applies only if the first cannot be established. That is, only if the writ of execution cannot be served personally on the debtor. If the sheriff, on serving the writ, neglects to demand satisfaction of the writ by the debtor, and thereafter simply states in his return that he was unable to find sufficient disposable property, no act of insolvency is committed. And if the debtor fails on demand to satisfy the judgment or indicate sufficient disposable property, it is irrelevant whether or not the sheriff subsequently finds disposable property sufficient to satisfy the judgment. Judgment includes a provisional sentence judgment, even if the defendant has entered an appearance to defend the principal case. The judgment must be against the debtor in his own name and not, for example, in the name of a firm of which he is the sole proprietor. However, the judgment does not have to be one obtained by the sequestrating creditor. A creditor may sequestrate a debtor on the basis of nulla bona, return on a writ issued at the instance of another creditor, provided the other creditor has not, in the interim, been paid or agreed to accept payment of the judgment debt in installments. Whether the term court includes the small claims court is not clear. The demand to satisfy the judgment debt must be made of the debtor or his duly authorized agent. In other words, personal service is required. A demand made to some other party, such as the debtor's wife, does not suffice. The writ need not be served on the debtor at his residence or place of business. Section 8, subsection B requires only personal service and does not say where the service must take place. To indicate property, the debtor should tell the sheriff that the property is and what the property is and where it is, with enough particularity to demonstrate its sufficiency and enable the sheriff to attach and sell it. So, for example, a debtor does not indicate immovable property for these purposes if he merely states that he has property at another address or in a particular area or street. The term disposable property means any property which may be attached and sold in execution, even if it is situated in some other locality. It includes both movable and immovable property, and also incorporeal assets, such as book debts. It does not include immovable property which has been mortgaged, even it seems where the value of the property considerably exceeds the amount owing under the mortgage bond. But if the applicant himself is the first mortgagee of the immovable property, it is regarded as disposable. If the sheriff's return of service merely refers to movable property, it does not establish an act of insolvency. To avail as an act of insolvency, the return should refer to all disposable property of whatever description. It has been held that the expression money, property, or assets in the printed form commonly in use covers all disposable property. In the same case, Vira remarked, without special leave of court, no writ can be issued against immovable property until a nulla bona return has been made on a writ against movables. But there is no reason why, after having made inquiries in regard to movables, with the result indicated in the return, the sheriff should not also make the further inquiry whether the debtor is possessed of immovable property capable of attachment. On then receiving an answer in the negative, this could be incorporated in the return, thus establishing, in appropriate cases, an act of insolvency. If the debtor points out insufficient disposable property to satisfy the writ, the sheriff may refuse to attach it and make a return of nulla bona, in which event the creditor may apply for sequestration. The onus is then on the sequestrating creditor to establish that the property pointed out was insufficient to satisfy the judgment. If the sheriff attaches the property pointed out by the director and at the sale in execution the property does not realize enough to satisfy the judgment, the creditor may proceed to sequestration on the ground that the debtor has not indicated property sufficient to satisfy the judgment. To prove that the requirements of the subsection have been satisfied, the sequestrating creditor may rely solely on the sheriff's return of service, which is regarded as prima facie proof of the truth of its contents. The debtor may, of course, dispute the correctness of the statement in the return, but if the return, on the face of it, establishes an act of insolvency, the owner is on the debtor to show that the clearest and most satisfactory evidence that the facts set out in the return are incorrect. In the latter case, the debtor alleges that the sheriff's return was incorrect because it did not refer to the debtor's personal assets, the value of which, according to the debtor, well exceeded the judgment. The debtor said that when demanding payment and asking for assets to satisfy the judgment, the sheriff had referred only to the assets of Le Mans Auto Sales, the debtor's business, and had not asked the debtor to disclose his personal assets. There was no mention of the debtor's business in the writ, and the sheriff denied that he had specifically mentioned it when serving the writ. The court held that the probabilities were against the debtor, and that his allegation was insufficient to rebut the prima facie inference that the return was correct. The return relied upon by the sequestrating creditor must obviously be made by the officer who actually executed the judgment, and not by someone else. In De Wet versus Larish 2000, the nulla bona return before the court had been certified and signed by a sheriff who had not executed the judgment. The court ruled that the applicant could not rely on the return as proof of an act of insolvency. The court stated that the legal practitioner who draws up or settles an application for compulsory sequestration based on a nulla bona return should carefully scrutinize the return and, if it is defective or inadequate, should remit it to the officer concerned for rectification before initiating the application to court. C. Disposition prejudicing creditors or preferring one creditor. Section 8, subsection C states, if he makes or attempts to make any disposition of any of his property which has or would have the effect of prejudicing his creditors or of preferring one creditor above another. This subsection envisages two sets of circumstances: an actual disposition of property and an attempted disposition of property. If there is an actual disposition, it must have the effect of prejudicing the debtor's creditors or preferring one creditor above another. If there is an attempted disposition, it must be such that it would, if completed, have the same effect. Disposition is wide enough to include both a contract in which the debtor undertakes to dispose of property and the actual subsequent delivery of the property. For further explanation of the concept disposition, see 12.1. Only the effect of the disposition need be considered. It does not matter whether the debtor made the disposition deliberately to favor one of his creditors or recklessly without regard for its consequences. The debtor's state of mind in making the disposition is irrelevant. A debtor commits this act of insolvency where, for example, he refuses to meet one debtor whilst paying another in full, or sells an asset manifestly below its market value whilst failing to meet debts that have fallen due, or passes a mortgage bond over his immovable property to secure his indebtedness to one creditor whilst his business ventures are in financial difficulties and he is not paying creditors. In de Villiers case above, it was contended that a payment to a single creditor was preferential to that creditor and prejudicial to the remaining creditors, because if all the debtor's liabilities, whether due or not, had been made payable then, they would have exceeded the debtor's assets. The court rejected the argument. It held that an act of insolvency in terms of Section 8, subsection C, is committed only where there is an actual preference of one creditor above another, when more than one debt has fallen due. As the debtor had not failed to pay any debt when due, he had not committed an act of insolvency. It is not sufficient for the applicant to state boldly that the disposition in question has had the effect of prejudicing creditors. He must explain how it has had this effect. But an explanation is apparently not required if the disposition, on the face of it, is such that a reasonable person would infer that it is prejudicial to creditors. Proof that a disposition rendered the debtor's estate insolvent or more insolvent indicates prejudice to creditors, but the applicant need not establish insolvency in every case. In Naringsmittel GmbH versus Otto above, a disposition which left the debtor solvent, but so illiquid that he was unable to pay all of his debts, was held to be prejudicial to creditors. The court held that in each case, regard should be had to all the surrounding circumstances to ascertain whether there is prejudice. D. Removal of property with intent to prejudice or prefer. Section 8, subsection D. If he removes or attempts to remove any of his property with intent to prejudice his creditors or to prefer one creditor above another. This act of insolvency differs from the preceding one in two respects. A disposition of property is not required, mere removal being sufficient, and the intention of the debtor, not the effect of what he does, is important. The test for determining whether the debtor had the requisite intention is a subjective one. The intention may be inferred from the circumstances surrounding the removal. An example of a removal with intent to prejudice creditors is the sending of money or goods to a foreign country so as not to be available for the settlement of creditors' claims. E. Offer of arrangement. Section 8, subsection E. If he makes or offers to make any arrangement with any of his creditors for releasing him wholly or in part from his debts. An arrangement or an offer qualifies as an act of insolvency in terms of this subsection, only if it is indicative of the debtor's inability to pay debts. This criterion was clearly satisfied in Unisa versus Sumar above, where the debtor offered to pay his creditors 50 cents in the rand and intimated that if the offer was not accepted, he would consider surrendering his estate. If the debtor offers by way of settlement a lesser amount than that claimed and denies liability altogether or disputes the amount of the debt, he does not commit an act of insolvency, because it does not appear from his offer that he cannot pay the debt. On the other hand, if the debtor offers a lesser sum in settlement and expressly or by implication admits that he owes the full debt, then he commits an act of insolvency, because he tacitly acknowledges that he cannot pay the debt. The debtor does not have to make the arrangement or offer personally. One made by a third person with his knowledge and permission suffices. The object of the arrangement or offer must be to release the debtor from liability, wholly or in part. An offer of a certain amount in the rand, subject to the debtor being allowed an extension of time to pay the balance, does not amount to an act of insolvency. F. Failure to apply for surrender. If, after having published a notice of surrender of his estate which has not lapsed or been withdrawn in terms of subsection 6 or 7, he fails to comply with the requirements of section 4 subsection 3, or lodges in terms of section 4 subsection 3 a statement which is incorrect or incomplete in any material respect, or fails to apply for the acceptance of the surrender of his estate on the date mentioned in the notice of the surrender as the date on which the application is to be made. 3 acts of insolvency are embodied in this subsection. In each case, the debtor must have published a notice of surrender which has not lapsed or been withdrawn, and then he must have done one of the following. First, failed to lodge a statement of affairs with the master. Secondly, filed a statement of affairs which is incorrect or incomplete in a material respect. Or third, failed to apply for acceptance of surrender on the specified date. A material error or omission is one which may affect the minds of creditors in deciding whether or not to oppose the application for surrender. For example, the omission of a claim not of a trifling nature. G. Notice of inability to pay. If he gives notice in writing to any one of his creditors that he is unable to pay any of his debts, as per section 8 subsection G, the notice must be in writing. The debtor does not commit this act of insolvency by informing the creditor orally that he cannot pay his debts, although he does provide the creditor with evidence of actual insolvency. The words any of his debts are capable of being interpreted as meaning either any one of his debts or all of his debts, but the courts following the Afrikaans version of section 8 subsection G, een of ander van sy skulde, have adopted the former construction. Consequently, the debtor commits an act of insolvency if he gives notice of inability to pay any single debt. A typical example of this act of insolvency occurs where a debtor or his attorney writes to a creditor informing him that he is not in a position to pay the debt for the time being and offering to pay it in installments. It is usually said that the debtor must have intended to give notice of his inability to pay, but the court has regard not so much to the debtor's subjective intention as to whether a reasonable person in the position of the receiver and having knowledge of the relevant circumstances would have interpreted the document in question to mean that the debtor cannot pay his debts. The relevant circumstances are those existing at the time of receipt of the letter. The question is not how a reasonable person would have understood the letter in the light of events which occurred or knowledge which was obtained subsequently. The proper approach is to consider how the letter would be understood by a reasonable person in the position of the creditor at the time he receives it, taking into account that creditor's knowledge of the debtor's circumstances. A debtor who applies for an administration order in terms of Section 74 of the Magistrates Courts Act 32 of 1944 is required to state that he cannot pay any of his debts and hence may commit an act of insolvency in the process. However, the application has to be construed according to its tenor as a whole and not according to the meaning in isolation of certain words used in it. If it appears from the information provided in the application that the debtor did not intend the word unable to be taken literally, for instance, if it is clear that he has sufficient means to pay his debts and is simply unwilling to do so immediately, then he does not commit an act of insolvency. This was the position in Shaban and Co. Proprietary Limited versus Plank above, and Rodru Proprietary Limited versus Rousseau. In Shaban, the debtor's application for administration showed a very considerable excess of assets over his liabilities. The court held that the debtor's statement, "I am unable to liquidate my liabilities forthwith," was obviously not intended to be taken literally because his assets consisted largely of stock in trade and loose items for which a ready market existed. What he, in all probability, intended to convey was that although he could, if forced to do so, liquidate enough of his assets to pay his creditors in the ordinary course of his business, he was unwilling to do this as it would result in a fairly good business being liquidated. In Rodru, although the debtor stated categorically that he was nie in staat om my skuld te betaal nie, it appeared clearly from the rest of his affidavit and other annexures that he considered himself to be solvent and intended making contractual arrangements with all his creditors to pay them in full by way of monthly installments. In First Rand Bank Limited versus Evans 2011, the court held that where a debtor writes to his creditor informing him that he has applied for or being placed under debt review in terms of the National Credit Act 34 of 2005, he is necessarily informing the creditor that he is over-indebted and unable to pay his debts, and this constitutes an act of insolvency under Section 8, subsection G of the Insolvency Act. In First Rand Bank Limited versus Janse van Rensburg and a related matter 2012, it was held that the fact that a debtor applies for debt review in terms of the National Credit Act does not in itself amount to an act of insolvency in terms of Section 8, subsection G of the Insolvency Act, because the application does not involve any notice given by the debtor to the creditor in which the debtor declares an inability to pay one or more of his debts. H. Inability to pay debts after notice of transfer of business. If, being a trader, he gives notice in the Gazette in terms of Section 34, subsection 1 of his intention to transfer his business, and is thereafter unable to pay all his debts, Section 8, subsection H. Section 34, subsection 2 provides that as soon as a notice is published in terms of Section 34, subsection 1, every liquidated liability of the trader in connection with his business, which would become due at some future date, falls due forthwith, if the creditor concerned demands payment. The term debts in Section 8, subsection H includes debts which become immediately payable by reason of this subsection. Proof of inability to pay one debt may be accepted as proof that the debtor is unable to pay all his debts, but evidence that a debtor was unwilling or has refused to pay a particular debt is not enough to establish this act of insolvency. Second, the debtor in fact insolvent. Instead of, or in addition to, relying on an act of insolvency by the debtor, the sequestrating creditor may rely on the fact that the debtor's estate is insolvent. That is, his liabilities exceed his assets. If the creditor relies on an act of insolvency and is unable to establish that it was committed, but it is clear that the debtor is in fact insolvent, the court may grant a final sequestration order on the latter ground. Factual insolvency may be established directly by evidence of the debtor's liabilities and the market value of his assets, or indirectly by evidence of facts and circumstances from which the inference of insolvency is fair and properly deducible. For example, that the debtor has failed to pay his debts and admitted that he is insolvent. In Patel versus Sonday above, 2 default judgments had been taken against the debtor and a writ issued in respect of one of them had not been satisfied. In addition, the debtor had approached some of his creditors, those who knew him well, and requested them to participate in a distribution scheme. The court held that these facts raised a very strong prima facie view that the debtor was insolvent, and this view was confirmed by the statement of affairs given by the debtor in his replying affidavit. Insolvency cannot be inferred simply from the fact that the debtor has not paid his debts, or has requested time to pay, or has offered to pay a certain amount in the rand immediately and the balance later. 3.1.3 Reason to believe sequestration will be to advantage of creditors. Before the court can grant a final order of sequestration, it must be satisfied that there is reason to believe that it will be to the advantage of the creditors if the debtor's estate is sequestrated, as per section 12, subsection 1c. Creditors means all, or at least the general body of creditors. The question is whether a substantial portion of the creditors, determined according to the value of the claims, will derive advantage from sequestration. For sequestration to be to the advantage of creditors, it must yield at the least a not negligible dividend. If after the costs of sequestration have been met, there is no payment to creditors or only a negligible one, there is no advantage. The decisions on what constitutes a sufficient or non-negligible dividend are not harmonious. In Absa Bank Limited versus de Klerk and related cases, 1999, a dividend of 5 cents in the rand was regarded as sufficient. But in Esterhuizen versus Swanepoel and 16 other cases, 2004, a dividend of 10 cents was considered insufficient. And in Ex parte Ugunlaya and others, 2011, it was held that for voluntary surrender and compulsory sequestration in the North Gauteng High Court, Pretoria, the dividend must be at least 20 cents in the rand. To enhance the size of his estate, the debtor may renounce in favor of his creditors the protection afforded by Section 82, subsection 6, in respect of particular movable assets, so that these assets may be sold along with the rest of his property. In Cohen versus Jacobs, Stand 675, Dover Glen Proprietary Limited intervening, 1998, it appeared that the debtor's only asset, a piece of land, could, if rezoned, be sold for nearly 3 times the price offered for the property at a sale in execution. The court held that, in the light of this, a prima facie case had been made out that it would be to the advantage of the creditors to sequestrate the estate. The fact that there will be a significant amount for distribution after the costs of sequestration have been satisfied does not necessarily mean that sequestration will be to the advantage of creditors. Sequestration is, in a sense, merely an elaborate means of execution and, because of its costs, an expensive one too. It is necessary to compare the position of the creditors if there is no sequestration with their position if there is a sequestration. Sequestration will only be to the advantage of the creditors if it will result in a greater dividend to them than would otherwise be the case, for example, through the setting aside of impeachable transactions or the exposure of concealed assets, or if it will prevent an unfair division of the proceeds of the assets or some creditors being preferred to others. In the latter case, a debtor's only creditor applied to sequestrate his estate on the basis of a nulla bona return. The court held that the creditor had to satisfy it that there was reason to believe that after the costs of sequestration had been paid, he would recover an amount that was not negligible. Furthermore, he had to demonstrate some reasonable expectation that the amount would exceed the likely proceeds of ordinary execution. As he had given no information other than that he obtained a nulla bona return, he had failed to show that sequestration would be to his advantage. Compare Absa Bank Limited versus de Klerk and related cases above. In this case, it was held that where the debtor is insolvent and the creditor is not yet in possession of a judgment upon which he can execute, sequestration will be cheaper, quicker, and hence more advantageous than forcing the creditor to issue summons and obtain a judgment which the debtor will be unable to satisfy. Sequestration is usually considered to hold no advantage for creditors unless the debtor has assets valued in excess of the estimated cost of sequestration. However, the converse does not apply. The fact that there is more than the required minimum amount in the estate does not mean that the sequestration is assumed to be advantageous to creditors. The court does not have to be satisfied that sequestration will benefit creditors financially, merely that there is reason to believe that it will. The fact put before the court must satisfy it that there is a reasonable prospect, not necessarily a likelihood, but a prospect which is not too remote, that some pecuniary benefit will result to creditors. It is not necessary to prove that the debtor has any assets, provided it is shown either that the debtor is in receipt of an income of which substantial portions are likely to become available to creditors in terms of Section 23, subsection 5, or that there is a reasonable prospect that the trustee, by invoking the machinery of the Insolvency Act, will unearth or recover assets which will yield a pecuniary benefit for creditors. In Lotzel versus Rubenheimer, above, it was unsuccessfully contended that creditors would not benefit from sequestration because the debtor had no assets. The debtor had been a farmer immediately prior to the application, and he admitted ownership of a motor car claimed by his wife as her property. The court held that it was inconceivable that the debtor could have carried on farming operations, albeit unsuccessfully, without any assets, and accordingly that there was an unreasonable prospect of an inquiry revealing assets. Furthermore, an investigation might show that the motor car was available for the benefit of creditors. Again, in Commissioner South African Revenue Service versus Hawker Air Services Proprietary Limited, also Commissioner South African Revenue Service versus Hawker Aviation Partnership and others above, the debtor, a partnership, had been the beneficial owner of an aircraft and had transferred the aircraft to another partnership without receiving any discernible benefit in return. The court considered that the transaction could be avoidable disposition or disposition without value, or even a simulated transaction in fraud of the South African Revenue Service. There was thus a reasonable prospect that an investigation and an inquiry by a trustee would yield a benefit to the creditors of the debtor. The onus of establishing advantage to creditors remains on the sequestrating creditor throughout, even where it is clear that the debtor has committed an act of insolvency. In certain earlier cases, the view was taken that once an act of insolvency is proved, the court will require convincing reasons to persuade it that sequestration will not be to the advantage of creditors. However, more recently, the courts have held that the commission of an act of insolvency is not necessarily material to the question of advantage to creditors. Certain acts of insolvency, by their nature, tend to indicate advantage to creditors. For instance, a disposition of property which prejudices creditors or prefers one creditor above another, but other acts, for example, a nulla bona return, do not. 3.1.4 Friendly sequestration. There is nothing to prevent a debtor from having his estate sequestrated by an amicable creditor. The debtor may, for instance, arrange with a friend to whom he owes a debt and whom he is unable to pay that he, the debtor, will commit an act of insolvency. For instance, write saying that he cannot meet the debt, and the friend will then apply for compulsory sequestration on the strength of this act of insolvency. An application for compulsory sequestration brought by a creditor who is not at arm's length is generally referred to as a friendly sequestration. In Craggs versus Dedekind and Bartman versus Bartman and another, also Van Jaarsveld versus Rubach and Van Aert versus Borrit 1996, Conradi described friendly sequestrations as follows. Friendly sequestrations seem to share certain characteristics. Although, like pornography, they may be hard to define, they are easy to recognize. The debt which the sequestrating creditor relies upon is almost always a loan. It is usually quite a small loan, very often made in circumstances where it would have been apparent to the whole world that the respondent was in serious financial difficulty. Despite this, the loan is customarily made without security of any sort. It is seldom evidenced by a written agreement or even subsequently recorded in writing. The only writing that is produced to the court is the letter stating, with appropriate expressions of dismay that the debt cannot be paid, and sometimes for good measure, setting out details of the respondent's assets and liabilities. Very often, debtor and creditor are related. Fathers commonly sequestrate sons, wives sequestrate husbands, and sweethearts sequestrate each other, without, I am sure, any damaging effect on their relationship. In Smith versus Porritt and others, 2008, Scott remarked that in practice, friendly sequestrations or friendly liquidations of companies are commonplace, and in such cases, the motive of the creditor instituting proceedings is more often than not simply to assist the insolvent or company. The legal position in regard to friendly sequestrations may be summarized as follows. First, the mere fact that an application for compulsory sequestration is brought by a creditor who is prepared to cooperate with the debtor or who is motivated partly by a desire to assist the debtor does not preclude the granting of a sequestration order. An order should not be refused simply because there is goodwill between the parties. Secondly, however, the court must be mindful of the fact it being a matter of common experience that where debtor and creditor in sequestration proceedings are not at arm's length, there is considerable potential for collusion and malpractice. Collusion consists of an agreement between the parties to suppress facts or manufacture evidence in order to make it appear to the court that one of the parties has a cause of action or a defense. Examples of malpractice that typically arise in friendly sequestrations are reliance on non-existent claim, inclusion of protected non-saleable assets, overvaluation of assets, or underestimation of costs to convince the court that a significant dividend will be payable, and repeated extensions of the return date for final sequestration. Third, the way in which the sequestration process may be abused is aptly described in the following passage from Mutumkulu versus Rampersad and another, 2000. The steep increases in interest rates by banks and other lending institutions over the past year or two has resulted in a steady, if not fast-flowing stream of so-called friendly sequestrations. Indeed, among certain attorneys, it has become quite a cottage industry. The majority of applications are sparked off by the imminent sale of the respondent's property by the bank. The respondent hurries off to an attorney who is well known for his expertise in the matters and is briefed on the requirements for a friendly sequestration. He duly finds a creditor to whom he purportedly is indebted by virtue of an unsecured oral loan in an insignificant amount. He then supposedly writes a letter to his creditor, which could just as well be headed letter in terms of Section 8, subsection G of the Insolvency Act, in which, with suitable expressions of dismay and apology, he confesses to be unable to repay the so-called loan. It is not uncommon to find in different applications that the Section 8, subsection G letter contains precisely the same wording, which makes one suspect that the attorney specializing in these matters has these letters on a word processor, and an application for the sequestration of the debtor is then drafted in which the friendly creditor makes the necessary allegations and in particular expresses his concern for the interests of the body of creditors if the property under attachment were to be sold by public auction. A value of the property on the open market is then given and duly supported by a valuer who also puts up an affidavit. It is also a feature of these applications that the same valuer is employed in each of them. Invariably, the application is then moved as a matter of urgency on the afternoon of the day before the sale of the property. If a provisional order is granted, one has the curious phenomenon that the respondent who is cooperated so admirably up until that date cannot be served with the court order for a variety of reasons, including that he is evading service, is now living elsewhere, is away on business, or etc. The result is that the return date is extended for a number of times until the genuine creditors have lost interest in the respondent, and the rule is then discharged. Alternatively, the provisional order is confirmed. The friendly creditor makes no effort to have a trustee appointed or to prove his claim. No creditor takes steps to prove a claim because of a fear of contribution. The debtor waits for the dust to settle and, with his old creditors off his back, carries on business as normal. Number 4. As is evident from the above quotation, a friendly sequestration application may be, and often is, brought with the sole purpose of obtaining a stay of civil proceedings, and in particular the stay of an approaching sale in execution. The debtor resorts to a friendly compulsory sequestration rather than voluntary surrender to achieve the stay because the former procedure is better suited to his purpose. It may be obtained on an urgent basis and without preliminary formalities or advance notice to creditors. It involves a less strenuous onus, the applicant being required to establish merely that there is reason to believe that the sequestration will be to the advantage of creditors, not that it will be. And the result of the application is, initially, only a provisional order which must be served on the debtor and may be postponed and subsequently discharged at the instance of the sequestrating creditor. Number 5. A debtor may even use a friendly sequestration as a method of freeing himself entirely from his debts, as will be seen later. Where an application for sequestration is granted and the free residue in the estate turns out to be insufficient to cover the costs of sequestration, any creditor who have proved claims are obliged to contribute to these costs. If the creditor of the debtor in a friendly sequestration are made to believe, for example, because of the paucity of the known assets, that there is an appreciable risk that they will be called upon to pay a contribution should they prove claims, they will refrain from doing so. Where no claims are proved within 6 months after sequestration, the debtor may apply for his rehabilitation and is thereupon released from his debts. Number 6. In the light of the above considerations, the courts have accepted that they must, as a matter of policy, scrutinize every friendly sequestration with particular care to ensure that the requirements of the Act are not subverted and the interests of creditors are not prejudiced. In particular, the court should in each case require the following from the sequestrating creditor. First, full details of the creditor's claims and locus standi, for example, what the claim is for, when and where it arose, the creditor's relationship with the debtor, who acted for each of the parties, what circumstances rendered it necessary for the debtor to become indebted to the creditor, and the terms of payment or repayment. Secondly, if the debt is an unsecured loan, an explanation for the lack of security. Third, documentary evidence establishing that he has actually performed as alleged. For example, receipts, paid checks, withdrawal slips, and invoices. Fourth, full details of the debtor's realizable assets, including cogent evidence, not merely the creditor's opinion as to what the assets are likely to be raised on a forced sale. Any expert opinion by a valuer should be based on facts or information properly proved by the valuer or other witnesses and supported by the valuer's reasons. Fifth, if it appears that another creditor has already attached the debtor's property in execution, proof that prior notice of the application has been given to that creditor. And number 6, if he requires an extension of the return dates of the rule nisi, an affidavit setting out proper reasons for the extension. Number 3.2. Application for sequestration. 3.2.1. Form and content of application. The application is brought by way of a notice of motion supported by affidavit. For precedent, see Appendix 1, Specimens 2.1 and 2.2. The affidavit must be by the sequestrating creditor or anyone else who can attest positively to the facts. The founding affidavit must set out sufficient facts to establish the requirements for a sequestration order discussed above. The affidavit should contain the following information and averments. First, the full names, status, occupation, and address of the sequestrating creditor. It should be made evident that the creditor has locus standi to apply. Where the application is made in the name of an agent, the affidavit must indicate that the agent is duly authorized to bring the proceedings. If a director or an official of a company signs the affidavit on behalf of the company, he must allege that he is duly authorized to do so, or set out facts establishing as much. Secondly, the full names, date of birth, identity number, and marital status of the debtor, and if the debtor is married, the full names, date of birth, and identity number of his or her spouse, as per Section 9, subsection 3a. It should be made to appear that the court has jurisdiction to hear the application. It is generally not competent to join two debtors in one application, even where they are jointly and severally liable to the creditor. But joinder may possibly be allowed where all the interested parties consent or where there is complete identity of interests. Section 17, subsection 4b of the Matrimonial Property Act 88 of 1984 provides that an application to sequestrate the joint estate of spouses married in community of property must be made against both spouses. The section is peremptory and hence the creditor has to ascertain in advance which matrimonial regime applies. However, in terms of the proviso to the section, the court cannot dismiss an application for sequestration of a debtor on the ground that such debtor's estate is a joint estate if the applicant satisfies the court that, despite reasonable steps on his part, he was unable to establish whether the debtor was married in community of property or the name and address of the debtor's spouse. Further, failure to comply with Section 17, subsection 4b, does not per se invalidate the proceedings or the court's order. This, for example, in Tilal versus Dos Santos 1995, where the applicant had obtained a provisional sequestration order against a joint estate without joining the other spouse, and without satisfying the requirements of the proviso to Section 17, subsection 4b, the court granted an extension of the rule nisi to enable the applicant to serve the papers on the other spouse. Thirdly, the amount, cause, and nature of the claim, and a statement as to whether the claim is secured or not, and, if it is, the nature and value of the security, as per Section 9, subsection 3. It should appear from the information furnished that the sequestrating creditor is entitled to bring the application in terms of Section 9, subsection 1. If he applies as a cessionary, details of the cession should be given. Fourthly, the act or acts of insolvency committed by the debtor and or his de facto insolvency. If the creditor relies on an act of insolvency, he should follow the wording of the act in describing it, and set out the facts that give rise to the alleged act. Where the act of insolvency alleged is nulla bona, return, or written notice of inability to pay, the return or notice should be attached to the affidavit. If the return is incomplete or defective, the creditor or his legal representative should have it rectified by the relevant serving officer prior to proceeding with the application. If the return is on the judgment of another creditor, the sequestrating creditor must allege that the judgment remains unsatisfied. In an application on a return which is not recent, the creditor must make averments supported by facts that the debtor's position is unchanged. Where the creditor bases his application on the insolvency of the debtor, he should make an allegation to this effect and support it with some prima facie evidence of insolvency. Number 5. An averment that sequestration will be to the advantage of creditors and an explanation why this will be so. If reliance is placed on the fact that immovable property will form part of the insolvent estate, the applicant should adduce expert evidence establishing how much the property will probably yield for the free residue. The expert should set forth the amount that the property is likely to realize in an insolvency sale and the basis on which he has formed his opinion. Number 6. Any other relevant facts which might influence the discretion of the court in granting or refusing a sequestration order. For example, the fact that the debtor has a claim for damages against the creditor which is the subject of a pending action. Number 7. A statement that security will be furnished to the master and his certificate obtained as required by Section 9, subsection 3. If this has already been done, the certificate should be attached to the affidavit. 8. A statement that a copy of the papers will be lodged with the master with a view to obtaining his report in terms of Section 9, subsection 4. And number 9. A statement confirming that copies of the application will be furnished to interested parties as required by Section 9, subsection 4a, and that an affidavit will be filed before or during the hearing, setting out the manner in which the section was complied with. In preparing the application, the utmost care should be taken to see that the founding affidavit complies with the requirements of the Act, and that the applicant's case is properly made out. Originals of supporting documents need not be attached to the application, but must be available for inspection by the court. Save in exceptional circumstances and subject always to the overriding jurisdiction of the court. An applicant in motion proceedings may not introduce new matter in his replying affidavit. In Ace and Another versus Duplessis, Ferrara intervening, 2001, The court allowed an applicant to include as part of his case against the debtor the founding affidavit of an intervening creditor in a separate application for sequestration of the debtor's estate. The court held that the applicant could rely on this affidavit to show that the debtor was factually insolvent and had committed certain acts of insolvency. Noll observed, to adjudicate on the case without reference to the intervening creditor's papers would be artificial and could redound to the disadvantage of the general body of creditors. Should the applicant not be entitled to refer to such papers and rely on admissible evidence contained therein, he would of necessity wish to incorporate such evidence in his own case by way of affidavits. This would result in an unnecessary and costly duplication of papers. The respondent is not prejudiced by reliance on any evidence represented by the intervening creditor. He has had a full opportunity to canvass all the relevant issues. 3.2.2 Steps prior to adjudication on application. Number 1. Security for costs. A creditor who institutes sequestration proceedings is bound to prosecute them at his own expense until a trustee or provisional trustee has been appointed, as per Section 14, subsection 1. For this reason, he is required to deposit with the master security for the payment of all fees and charges necessary for the prosecution of all sequestration proceedings and of all costs until the appointment of a trustee or provisional trustee, or if none is eventually appointed, all fees and charges necessary for the discharge of the estate from sequestration. A certificate from the master that the necessary security has been lodged must be given not more than 10 days before the date of the application and must accompany the application, as per Section 9, subsection 3. In relation to this latter requirement, the courts have held that, first, the expression date of the application refers to the date of signature of the notice of motion, not the date of the hearing. The intention of the legislature being that the party giving security should have 10 days after doing so to proceed with his sequestration application. And secondly, the requirement that the certificate accompany the application means merely that the certificate must be before the court when the application is heard, not that it must accompany the application when it is filed with the registrar or served on the respondent. Number 2. Search of master's records. In the Western Cape High Court, it is a rule of practice that the applicant's attorney must file an affidavit stating that he has searched the records in the master's office, and it does not appear from that search that the debtor's estate is already under sequestration, or that he was published in a notice of intention, or that he has published a notice of intention to surrender. Third, filing of application at court. The applicant must file the notice of motion, founding affidavit, and supporting documents with the registrar prior to the hearing of the application. Number 4. Master's report. Before an application can be adjudicated on by the court, a copy of the notice of motion and the founding affidavits must be lodged with the master, as per Section 9, subsection 4. If there is no master at the seat of the court, the papers must be lodged with the officer in the public service designated for that purpose, by the master in the Gazette. The master or the designated officer may then make a written report to the court of any facts which he has ascertained which would appear to him to justify the court in postponing the hearing or in dismissing the application. For example, that the debtor's estate has already been sequestrated. A copy of this report must be transmitted to the sequestrating creditor or his agent, as per Section 9, subsection 4, who may file an answering affidavit if he wishes, as per Section 9, subsection 5. Number 5. Copy of papers to debtor and other parties. On presenting his application to the court, the applicant must furnish a copy of the application to the debtor as per Section 9, subsection 4A, A4. However, the court may, in its discretion, dispense with this requirement and make a provisional order of sequestration without advance notice to the debtor, if it is satisfied that this would be in the interests of the creditors or of the debtor. Since this section does not use the term serve but rather the word furnish, which is not a term of general application on civil practice or procedure, it seems clear that the legislature intended that informal service would suffice. The creditor would necessarily have to make out a case in this founding affidavit to dispense with the furnishing of the application. Relevant factors in this regard include the urgency of the matter and the conduct of the debtor in relation to his assets. The court should obviously weigh up the respective interests of the creditor and the debtor and take account of any potential prejudice to the creditor if the debtor is forewarned of the impending application. As to the practice of the various high courts before the introduction of Section 9, 4A.A.4. In view of this section, it would seem that it is no longer permissible for a court to grant a provisional order ex parte merely because the applicant has clear documentary evidence, such as a nulla bona return. For criticism of the latter practice, see Stride versus Kastelstein, 2000. See also Standard Bank of South Africa Limited versus ESOP 1997, in which it was held that a clause in a settlement agreement that entitled a creditor to reinstate a sequestration application without notice to the debtor was contrary to public policy. In addition to providing a copy of the application to the debtor, the applicant is required to furnish a copy to first, every registered trade union that, as far as he can reasonably ascertain, represents any of the debtor's employees. Secondly, the debtor's employees themselves. And lastly, the South African Revenue Service. As per Section 9, subsection 4A.A.123. The employees referred to here are those employed by any business of the debtor. So, for example, there is no need to furnish a copy of the application to workers employed at the debtor's residence. The applicant must furnish the debtor's employees with a copy of the application in one of the following ways. First, by affixing a copy of the application to any notice board to which he and the employees have access inside the debtor's premises, or secondly, if the applicant and the employees do not have access to the debtor's premises, by affixing a copy of the application to the front gates of the premises, or lastly, failing to the latter, by affixing a copy of the application to the front door of the premises from which the debtor conducted any business at the time of the presentation of the application. The applicant is obliged before or during the hearing to file an affidavit by the person who furnished copies of the application to the debtor and other parties mentioned above, setting out the manner in which he complied with the requirements of the Act in this regard, as per Section 9, subsection 4A.B. In Standard Bank of South Africa Limited versus Supershad and another, 2005, it was held that the requirements of giving of notice to all interested parties and filing an affidavit detailing what has been done are peremptory, therefore must be complied with. However, it seems that the court will insist on exact compliance with these requirements only to the extent that the applicant is able to do this. In Hanover Reinsurance Group Africa Proprietary Limited and another versus Gangudu and another 2012, the applicants did not serve the application on the respondent's employees and file the appropriate affidavit because there was no indication that the respondent had employees. The court rejected the argument that non-compliance with Section 9, 4A, A, and B was fatal to the application. It pointed out that compliance with these requirements presupposes knowledge of the existence of employees, or at least reasonable grounds to suspect that there may be employees. The court added that even where the applicant suspects that there may be employees, if he cannot obtain further information, the best that he can do is to state that he is unable to determine whether they are employees or whether they are unionized. Similarly, in Hendricks N.O. and others versus Cape Kingdom Proprietary Limited 2010, a case dealing with equivalent notice requirements under Section 346, subsection 4A and 346A of the Companies Act 61 of 1973, it was accepted that personal notification to the relevant employees instead of notice in the prescribed manner will suffice if the employees are no longer at the company's principal place of business or at its alternative premises. In terms of Section 197B, subsection 2 of the Labour Relations Act 66 of 1995, an employer who receives an application for sequestration of his estate must supply a copy of the application to any consulting party as contemplated in Section 189 of that Act. The meaning of consulting party, which appears from Section 189, is essentially the party or parties from whom the employer would be obliged to consult when deciding whether to dismiss an employee for operational reasons. 3.2.3 Provisional sequestration. The sequestrating creditor has to approach the court twice, once to obtain a provisional order of sequestration per Section 10, and the second time to have the provisional order confirmed and made final as per Section 12. On each occasion, the creditor must establish the same requirements, but the standard of proof differs. At the provisional stage, the court must be of the opinion that prima facie the requirements for a sequestration order are satisfied. At the final stage, the court must be satisfied that those requirements are proved on a balance of probabilities. When an application is made for a provisional order of sequestration, the following must be before the court. First, the notice of motion, including a draft of the desired provisional order of sequestration and the founding affidavits. Secondly, the master's certificate that security has been given. Third, the affidavit of search made by the sequestrating creditor's attorney in the Western Cape. Fourth, the master's report, or if none, proof of service of the papers on him. Fifth, the sequestrating creditor's affidavit, if any, responding to the master's report. And number 6, an affidavit by the person who furnishes copies of the application to the debtor and other interested parties in compliance with Section 9, subsection 4AA, setting out the manner in which this was done. After considering the documents placed before it, the court may make an order sequestrating the estate of the debtor provisionally, or it may dismiss the application, or it may postpone the hearing, or it may make such other order as appears to be just in the circumstances, as per Section 9, subsection 5. On making a provisional sequestration order, the court must simultaneously grant a rule nisi, that is, an order calling upon the debtor to show cause on a day mentioned in the rule, why his estate should not be finally sequestrated, as stated in Section 11, subsection 1. An order of provisional sequestration gives the creditor a simple and speedy remedy for preserving the debtor's estate and enforcing his claim. The court may make the order based on incomplete information or hearsay evidence, although it cannot rely on evidence obtained in the violation of the debtor's constitutional rights. What amounts to a prima facie case for the purposes of Section 10 differs according to whether the debtor has placed facts in dispute. If he has not done so, the test is that normally applied to determine whether a litigant has established a prima facie case, namely whether the creditor's allegations, if taken to be true, satisfy the requirements for a sequestration order. If the debtor has raised a factual dispute, the test for establishing a prima facie case is whether on a consideration of all the affidavits, that is, those filed for both creditor and debtor. The requirements for sequestration are established on a balance of probabilities. In Khalil versus Dicotex Proprietary Limited and others, 1988, Corbett explained the reasons for the difference in approach. Where the application for a provisional order is not opposed, or where, though it is opposed, no factual disputes are raised in the opposing affidavits, the concept of the applicant upon whom the onus lies having to establish a prima facie case seems wholly appropriate, but not so where the applicant is opposed and real and fundamental factual issues arise on the affidavits, for it can hardly be suggested that in such a case the court should decide whether or not to grant an order without reference to respondents' rebutting evidence. If in an opposed application the creditor succeeds in establishing on a balance of probabilities in his favor, the court will generally refuse any application by the debtor to refer the matter to oral evidence, to disturb the balance of probabilities. If the creditor cannot show that the probabilities favor him, he may apply for an order referring the matter to oral evidence. The court will be more inclined to grant this application if the probabilities are evenly balanced than if they favor the debtor. The courts accept the proposition that since sequestration procedure does not exist to settle dispute claims, if the debtor disputes the creditor's claim genuinely and on reasonable grounds, then irrespective of where the probabilities lie, the court should postpone the sequestration proceedings until after the creditor has proved his claim. In Payslip Investment Holdings CC versus Y2K Tech Limited above, Brand observed, a distinction is drawn between disputes regarding the respondent's debtor's liability to the applicant or creditor and other disputes. Regarding the latter, the test is whether the balance of probabilities favor the applicant's version on the papers. If so, a provisional order will usually be granted. If not, the application will either be refused or the dispute referred for the hearing of oral evidence, depending on, inter alia, the strength of the respondent's case and the prospects of a viva voce evidence tipping the scales in favor of the applicant. With reference to disputes regarding the respondent's indebtedness, the test is whether it appeared on the papers that the applicant's claim is disputed by respondent on reasonable and bona fide grounds. In this event, it is not sufficient that the applicant has made out a case on the probabilities. 3.2.4 Service of Rule Nisi. The Rule Nisi, together with the application papers, if the debtor has not already been served with them, must be served on the debtor in accordance with the rules of court. If the debtor has been absent for 21 days from his usual place of residence and from his business, if any, within the Republic, the court may direct that the rule will be sufficiently served if a copy is attached to the door of the courthouse and published in the Gazette, or the court may direct some other mode of service, as per Section 11, subsection 2. It has been held that this provision is permissive and not peremptory. If the court decides to give instructions about service, it need not choose the mode of service described in the Act, but may determine and select the most practical way of bringing the rule to the attention of the respondent. A copy of the Rule Nisi must also be served on any registered trade union that represents the debtor's employees, as per Section 11, subsection 2a. The employees themselves, as per Section 11, subsection 2a(b), and the South African Revenue Service, as per Section 11, subsection 2a(c). Service on the debtor's employees must be effected either first by affixing a copy of the papers to a notice board to which the employees have access inside the debtor's premises, Secondly, if they do not have access to such premises by affixing a copy of the papers to the front gate, or lastly, failing the latter by affixing a copy of the papers to the front door of the premises from which the debtor conducted any business at the time of the presentation of the application, as per section 11, subsection 2a(b). For the purpose of effecting service in accordance with the above requirements, the sheriff must establish whether the employees are represented by a registered trade union and whether there is a notice board inside the employer's premises to which the employees have access, as per section 11, subsection 4. 3.2.5 Opposition to application. After granting of the rule nisi, the debtor, if he has not already done so, and other interested parties, may oppose the application by filing affidavits with the registrar setting out the grounds of their opposition. These affidavits must be served on the sequestrating creditor in sufficient time to enable him to reply before the return day. If a provisional trustee obtains information which has a bearing on the various matters arising for determination on the return day, he may place the information before the court by way of affidavit, although he is under no statutory duty to do so. 3.2.6 Anticipation of the return day. On the application of the debtor, the court may anticipate the return day of the rule nisi for the purpose of discharging the provisional order, provided 24 hours notice of the application has been given to the sequestrating creditor, as per section 11, subsection 3. The court will anticipate the return day only if it is satisfied that all creditors, not merely the sequestrating creditor, have been given notice and that none has any valid objection, or if it is obvious that creditors will not oppose the discharge of the rule. 3.2.7 Intervention by another creditor. In Fullard v. Fullard, 1979, the position regarding intervention by a creditor was stated as follows. A creditor is entitled to intervene at any stage, either to have the provisional order set aside, or where the sequestrating creditor withdraws his application or drags his feet, to obtain a fresh sequestration order in his own right and name. In the latter event, the existing sequestration order cannot be confirmed at the instance of an intervening creditor. It must be set aside and a fresh order issued with the intervening creditor as the applicant. He then becomes the dominus litis, and the original applicant drops out of the picture. The intervening creditor must make out a case for sequestration, furnish security for costs, etc., as though he were the original applicant. But he does not have to restate facts which appear from the record in the existing proceedings. The court takes a practical view in these matters and also bears in mind the interests of the general body of creditors. In M&V Tractor and Implement Agencies BK versus Vennootskap DSI Cilliers en Seuns en andere, Kelder Vervoer, IDMS BPK, Tussenbytredend 2000. The court pointed out that intervention by a creditor in insolvency proceedings differs substantially from conventional intervention and is, from a procedural point of view, sui generis, being a substantive application which is launched when the creditor arrives at court with his own evidence, usually on the return day. 3.2.8 Final sequestration. On the return day, in addition to the papers filed at the provisional stage, the court must have before it, first, the sheriff's return of service of the rule nisi, secondly, any opposing affidavits of the debtor and or other interested parties, thirdly, the replying affidavit of the applicant, and lastly, any affidavit by the provisional trustee. The practice is for the applicant's counsel to appear in court and ask for the provisional order of sequestration to be made final, or for alternative relief. The insolvent may appear personally or be represented by counsel to oppose the granting of a final order, and other creditors may appear to oppose or support it. The sequestrating creditor bears the onus of proving on a balance of probabilities that the requirements for final sequestration have been met. There is no onus on the debtor but an evidentiary burden to show that the provisional order is resisted on bona fide and reasonable grounds. If the court is satisfied that the creditor has discharged the onus resting on him, it may confirm the provisional order. If it is not so satisfied, it must either dismiss the application and set aside the provisional order, or require the creditor to produce further proof of the allegations in his application and postpone the hearing for a reasonable time, but not sine die, per section 12 subsection 2. The court may allow such further proof in a replying affidavit, subject to the debtors being allowed an opportunity to deal with the new matter. It has been held that since the ordinary procedure for settling disputed questions of fact is by viva voce evidence, the court cannot make a final order of sequestration on papers which raise disputes of fact unless it is satisfied that oral evidence will not disturb the balance of probabilities. Whether, in particular circumstances, an application for sequestration should be dismissed or whether further proof of insolvency should be allowed is a matter relating to the conduct of the business of the court hearing the application. A court of appeal can interfere only if the court a quo exercised its discretion capriciously, or upon a wrong principle, or did not bring its unbiased judgment to bear on the question, or did not act for substantial reasons. When a provisional order of sequestration has been made final, the date of sequestration is thereafter for all purposes taken to be the date upon which the provisional order was originally granted, and not the date upon which it was made final. Number 3.3. Court's discretion. Even if the court is satisfied that the requirements discussed above have been established on a balance of probabilities, it is not bound to grant a final order of sequestration. In each case, it has an overriding discretion to be exercised upon a consideration of all the circumstances. This, the court exercised its discretion against sequestration, notwithstanding proof of an act of insolvency and the other requirements of a sequestration order, where the debtor furnished independent evidence that his estate was solvent. The fact that the debtor has committed an act of insolvency is an important consideration in the decision whether his estate should be sequestrated. In Metje and Ziegler Limited versus Karstens 1959, Hall considered that it places the sequestrating creditor in a much stronger position than a mere general allegation of insolvency. In De Waard versus Andrew and Tinaus Limited, 1907, Solomon held, "In my opinion, where it is clearly proved that a man has committed an act of insolvency, it is a matter of discretion for the judge to decide whether or not he shall sequestrate the estate, and he is not debarred from doing so merely because the debtor produces evidence to show that his assets are in excess of his liabilities. In such cases, the judge may either sequestrate the estate, or he may, in the exercise of his discretion, give the insolvent time to pay." 3.4. Costs of proceedings. The trustee must, from the first available funds of the estate, reimburse the sequestrating creditor his taxed costs in sequestrating the debtor's estate, per section 14 subsection 2. No claim need be proved for these costs, as they are part of the costs of sequestration. Costs of opposition to the sequestration are not paid as part of costs of sequestration, unless the court has so ordered when granting the final sequestration order, as per section 97 subsection 3. The court will make this order only if it considers that the opposition was with bona fide and reasonable. Reasonable in the sense that there were reasonable prospects of its being successful. The costs of intervention by a creditor are regarded as sequestration costs if the intervention was necessary and bona fide. A creditor who has been put to the expense of intervening to oppose an application of questionable merit may be awarded costs on the attorney and client scale. 3.5. Unwarranted or vexatious proceedings. As a safeguard against abuse by creditors of the power to bring compulsory sequestration proceedings, the Act provides that whenever the court is satisfied that an application for sequestration is an abuse of the court's procedure or is malicious or vexatious, it may allow the debtor forthwith, for instance, at the hearing of the application for final sequestration, to prove any damage which he has sustained by reason of the presentation of the application, and award him such compensation as it may deem fit, as per section 15. The debtor is not, however, confined to this method of obtaining summary relief, and may, at his option, institute action at common law to recover damages on the ground that the creditor brought the proceedings maliciously and without reasonable and probable cause. 3.6. Setting aside sequestration order. Any person aggrieved by a final order of compulsory sequestration or by an order setting aside an order of provisional sequestration may appeal against the order as per section 150 subsection 1. The aggrieved person must first obtain leave to appeal from the appropriate court, as per Section 150 subsection 1 and Section 20 subsection 4 of the Supreme Court Act 59 of 1959, and the appeal must be prosecuted with due expedition. No appeal lies against either the granting of a provisional sequestration order or the refusal of such an order. The power of the court to rescind or vary a sequestration order in terms of Section 149, subsection 2, and Section 54, subsection 5, has been discussed in the previous chapter. In Rutherford v. Ferguson and others, 2000, an insolvent whose estate had been compulsorily sequestrated sought a declaration in terms of Section 19, subsection 1A3. Of the Supreme Court Act 59 of 1959, that the court which had granted the sequestration order had lacked the necessary jurisdiction to do so, and accordingly that the sequestration order was a nullity. The insolvent did not indicate whether he opposed the sequestration, why he could not obtain relief by appealing in terms of Section 150 of the Insolvency Act No. 24 of 1936, the extent to which the liquidation and distribution of the estate assets had progressed, and why the creditors who had received dividends, if any, had not been joined as respondents, since they would be detrimentally affected by a declaration of nullity. The court upheld an exception that the particulars of claim failed to disclose a cause of action. In the court's view, the insolvent had failed to show that existing, future, or contingent rights and or obligations were the object of the declaration, and had further failed to make out a case on which the court could exercise its discretion in terms of Section 19, subsection 1A3 of the Supreme Court Act 59 of 1959.